Buckle up. You're exiting the ordinary and entering the court gallery. Yes. It is President's Day in the United States of America. Courts have been closed. Most courts have been closed most of the day. There have been some courts that have been open. Judge Stevens was active. He had a bunch of stuff going on, but we're not watching any of that tonight. No. I have a huge backlog of cases that I've been trying to get through, and I just can't find the time to show everything that I have to show. So tonight, we're turning things back. We're going to the Wayback Machine. We're going way back to Thurston County Court on February the 13th, all the way back to last Friday. And we're going to watch a nightmare neighbor case that is, it's something else. But I'll let you. Description, as always, time codes, all that good stuff. Our second case that we're going to look at tonight is Judge DiSanto, and it's a very upset driver who says some very mean things to the officer. It's a prelim exam, and it's a nice link. And we're going to end things off with Judge Stevens, and he's got a guy who wants to be pro se, wants to defend himself, wants to bring the body in front of the court, and he gets exactly what he wants, and it may not be exactly how he expected it to turn out. It all starts, ladies and gentlemen, right now.
Let's have the McNeils come up, please. If you'd raise your right hand for me. Swear that testimony in this case will be the truth, whole truth, and nothing but the truth.
I do.
You may have a seat. The Coxes are neighbors.
Correct.
Okay. So, what started the issue here? I mean,
I have some more, I have an updated attachments for that from things that occurred last night after we submitted our evidence.
Just tell me what happened.
So as far as which began, or as far as the updated?
Okay, so the Coxes and the McNeils are neighbors.
Yes.
And sounds like shortly after you moved in or after they moved in, I wasn't sure who was there first. There was a disagreement during the Black Lives Matters protests.
That wasn't a disagreement. That was just a situation where we were having a conversation and he was explaining to me his viewpoint on using violence or weapons or firearms to defend himself and anyone that came up against him. So it was said to me to be interpreted so that I would know that he will do whatever means necessary to defend himself.
And why do you think it was directed at you rather than just saying?
When we moved in, there'd been tensions from the beginning. They didn't like our dog. So we chose to give our dog away so that we could be good neighbors and that we could set kind of a precedence. Shortly after, they didn't care for the sound that comes from my shop that's on the property. So they would ask and complain about it being too loud. So that kind of escalated over the years, but was manageable as long as we were willing to meet and speak, and we could usually navigate that. What kind of brought things to a head was they had said that they were going to move their fence further onto our property. And I had told them, I don't like that. It cuts off access to my building. I'd have to cut down 7 of my trees, cut down my expensive gate, metal gate, and that I would be more than happy to help pay for the fence if we keep it where it's been for the last 20 years. So we had come to an agreement where they were going to put removable sections in so that we could have access to the backside of our property. So when they put that section of fence up and did not put in removable sections of fencing, that's when I called a lawyer. So my lawyer at that point said, do not have communication with them. Let's just see how things go. There's another section of fence that we're expecting them to deal with, in which case they will have to cut down our trees and cut down our gate to have access to that, to move the fence line. And so when it came time for them to do that, I did not cut down my trees. I did not move my gate. And so they cut down the trees and cut down the gate. And that's when the harassment really started, with the signs, the cameras, those types of things. It was only over the last 2 weeks that the music has been directed towards our children, where now our children are being harassed. So I don't know what catalyst there is for the last 2 weeks that's instigated this, but I'm assuming that this has to do with us not complying with their request to cut down our trees and move our gate. They, to my knowledge, are unaware that we have a lawyer and that we are working on dealing with the boundary line. I would imagine if they did know that this harassment would only be worse. So I don't know how that's going to play out yet. The lawyer is still looking into, he's going to interview neighbors next week and some stuff like that. So, but in the meantime, we're just really up against the frustrations here. So to harken back to the Black Lives Matter protest, that was just a point in time. I don't have the exact date of when that conversation happened, but that's all that was.
Okay, I was just trying to figure out what this is about. So.
Sorry.
But the dog and...
You do have a timeline of events you're on.
Yeah, I looked through that.
Okay.
Okay, so he has the cameras up and the loud music. Those are the actions they've taken that are
the signage as well. The signage is offensive. We don't appreciate that. The other thing that we feel is harassment are the false claims to governing agencies.
Both of those things are probably something the court's not going to do anything about.
And that's understandable, but that's what we're bringing to the table.
Right.
Like, that's what we feel is being harassed.
And have you made loud music complaints to the county?
I called Thurston County Sheriff, and they said that we need to file a harassment report. I gave them the details of the situation. I explained the context of what is happening and just how it's very intentional towards our children. And they said the only options that we have is to try to get some kind of an anti-harassment order.
You've lived there 20 years?
We have lived there since 2009. Our lawyer has discovered that fence has been there for roughly 20 years.
Okay. So since you've lived there, has the music been a constant, or does the music show up when things get tense between?
Well, that's only happened over the last 2 weeks. Okay. So the music is a brand new development, and it's only now that the weather's getting nicer when our children are outside playing. And so they wait for our children to be there to then play the songs that they're playing.
Gotcha. Having handled a case recently where something similar was going on, the county noise ordinance would, I think, apply between the hours of daylight and 10 p.m. or something. So, or between 10 p.m. and daylight. So that's when quiet is required. Loud music is much harder to regulate prior to that, while people are technically awake and that sort of thing. But your concern necessarily isn't just about the loudness, it's about the lyrics and the impact it has on your children. So yeah, I understand that.
we don't feel that exposing our young kids to that type of sexual content is appropriate.
And have you mentioned that to them? Are you still at the point where you could talk with them, or is that not something you can do now?
So in light of what happened last night, I contacted my lawyer to say, I know that I've been advised not to have communication with them. However, I've already submitted a form to the court. Can I talk to them? Can I ask them to turn off their music? And he said yes, because that harassment issue is a separate issue from the one that he's dealing with. He said, go knock on their door. I explained I couldn't knock on the door because I'm watching my kids. Can I text them? So he said, yeah, text them, see if they reply. So I texted them. They did not reply, but they did turn the music up in volume.
I think you got your answer, huh?
I'm pretty confident.
Yeah, okay.
We have made every attempt to communicate with them one-on-one and have conversation for years. And every time there's been a grievance or a complaint, it's been them coming to us asking to change our actions, which we've complied. We haven't had to, we're not obligated to. But now that we've had the first, hey, this is an offense to us, like we would like to discuss you not taking this action, they have just gone full ballistic. And there's just no ability to have conversation.
Have they made any sort of threats?
They have not made threats saying we are going to kill you, we're going to shoot you. They have not said those, which I know if they had would change things. But
They're just making it obnoxious for you to have them as neighbors.
incredibly.
And they're your immediate neighbors.
Correct, Your Honor.
They ever come onto your property?
I feel they've come onto our property.
Is that the boundary issue?
Yeah, that's part of the boundary dispute.
And has an action been filed on that yet?
Not yet. The interviews, our lawyer is interviewing the remaining neighbors, what sounds like next week. And when that's concluded, then we may file.
Has there been a survey of the boundary line?
There has been a survey, yes.
And does it show in favor of the Coxes or in favor of the?
It shows in favor of the Coxes. So one of our approaches, from what I understand, is that he's going to be looking for adverse possession. He believes we meet the requirements of that. We've planted trees in that space. We've owned it, or utilized it. Yeah.
We also rebuilt the fence previously.
All right. So my guess is this will be an ongoing issue going forward.
Yeah, this is not going to be a fun existence.
Yeah.
He is a mid to high level manager for Grays Harbor County. So he's used that position to kind of threaten, for lack of a better word, or hold us under his thumb in regards to what we do on our property. So he's done that to other neighbors as well. So we just really feel like we're up against a bully, and we're just, at some point, we kind of have to stand up to a bully.
So one of your complaints is about the cameras that you believe are surveilling you. And they're going to come in and say, no, they're to cover the boundary line of their property, which is, somebody's right to have security cameras. Have they posted videos online that you've seen that show, wait, they're not serving that security purpose. They actually are.
I've been blocked. They've blocked us from their social media. So to my understanding, I don't know.
Okay. So I asked that question so you will realize how difficult that's going to be to address the camera issue.
We installed our cameras after the fact in light of this, and we've installed them at the fence line or lower so that we get full view of our property and none of theirs. And they have 20-foot tall turrets that they can rotate the cameras around to get 360 view. I think they can still observe their property without having to have access to all of us surrounding neighbors' properties.
Okay. That also be a somewhat problematic issue to try to figure out how you set limits on that. You know, as we look at it from not, you know, I'm not a neighbor, obviously. So, you know, I just have to look at it dispassionately.
Mm-hmm.
You know, I'm going to hear two arguments. And that one is it's just their security cameras protecting their property, and yours is no, they're surveilling us as a means of harassment. So I'll have to figure where that line might be. And I can't do that today without them here to hear their side of it. I am convinced that the music is being played as a direct means to harass you based on the timing of it and the nature of it. I'll try to construct something here. So I think what you've told me is it's directed at your children when they're outside.
Those are the only times it's happened, is when shortly after our kids go out to play.
Okay. It's almost be kind of the reverse of what we typically do, which is say you can't play your loud music at night, but here it's almost like you can play it at night once the kids are in bed, but you can't play it during the day when they're out back.
The loud music, I don't mind if they were having a party, if they were enjoying the music, but it's done intentionally.
Yeah,
I
hear what you're saying. So there are decibel levels that are, I believe, are set forth in the county ordinances. You might be well advised to have somebody come out and measure decibel levels when the loud music is playing, so you have something to present the court. Besides just, you don't like their loud music, and they're going to say it's not all that loud. They listen to it for personal enjoyment, and the court, you're going to put the court in a tough position trying to figure that out. So getting a number on the decibel level would probably be something smart to do.
We do have a video that shows a decibel reading of it at around 60 decibels, which I think we submitted to
I haven't seen the video. I'm just
okay.
And I can't remember where 60 falls on the decibel ordinance.
I think 55 or ish or whatever was the max allowed for Thurston County.
Right. Okay.
But yeah, we can continue to monitor that.
So you have a decibel meter that you use?
Correct.
Okay. Well, then you don't need somebody to come out. You have a decibel meter.
Yeah.
Okay.
When we spoke to Thurston County Sheriff, they said as far as the sound goes, there's really nothing we can do.
Mm-hmm.
They said if it's after 10 p.m., we could ask them to stop. But if the music continues and we keep calling Thurston County Sheriff, they're going to continue to say, like, we're just not able to do anything about it. So our only reason for being here is to try to get the intentional harassment to stop. Mm-hmm. We're not grievances about other nuisances that they've given us. We're just, you know, these intentional things are what we're looking to have dealt with.
Okay. As I said, this is going to be problematic. The limitations I put on them, I will enter a temporary order. Those orders are not to have direct contact with you or your family members. And I've also indicated that they are to control the volume of the music to comply with county noise ordinance. So you are going to want to measure the volume and see if they're exceeding that. You know, as to the content of the music, we have the First Amendment, and, you know, that really restricts my ability to say you can't play obscene music when kids are around. So probably nothing the court can do for you in that regard. So my apologies, but, and then as I'd indicated earlier, we can't as long as signs aren't on your property, we really can't regulate their expression unless it was threatening. And we can't keep them from calling all the agencies they're calling to come, file complaints with all of them and make them come out and talk to you and find out there's no issue there. The agencies will have to decide not to respond to the Cox's complaints when they keep realizing you haven't done what they've said you've done. So unfortunately, a lot of what you're asking for, court can't step in and regulate. Now, there may be a way in suing them that if they are engaged in harassment, you make it as part of a civil lawsuit, the court can construct something much broader. We're limited here by the anti-harassment statute. So I can't regulate legal activity.
Okay.
So just so you know.
Okay.
Thank
All right.
you, Your Honor.
If you'll wait outside, I've signed the order. There will be a hearing on the 23rd of February at 9:00. And the Coxes need to be served a copy of this. I think it was, you said the sheriff's office that appears out there, is that
Yeah.
right?
Mhm.
So would you like them to do the service?
I believe so, yeah.
Okay. So if you'll wait outside in just a moment, you're going to be given a copy of the service packet, and you can just walk it across the hallway to the sheriff's office.
Thank you, Your Honor.
Great.
You're
Thank
welcome. I hope it quiets down for you.
Yeah.
Thank you.
Yeah.
Okay, and then we are on the record in the matter of the state of Michigan versus Terrence Brown, 221305. And appearance for the people, please.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Good afternoon, Your Honor. Tanika Tucker, PA 5402 on behalf of Terrence Brown.
Thank you. And Mr. Brown, if you can please stand up and state your name for the record, please.
Terrence Brown.
All right, thank you. Okay, and today's the date scheduled for preliminary examination. This matter I show on 5 counts, correct?
Yes.
2 counts of assaulting, resisting an officer. Well, then there's the other ones are misdemeanors, driving while suspended, second offense, OWI, second offense, and no insurance, correct? All right, so the exam is on the 2 felony matters. Are there any preliminary matters that we need to address prior to commencing with testimony?
Yes, there are a few. The first is I'm going to request a mutual order of sequestration and an exception to the officer in charge, Detective Chelsea Haskins.
All right, and Ms. Tucker, any response, any objection? All right, the court will order mutual sequestration order, OIC exception. If there's anybody in the courtroom that's expected to testify, you're going to have to remove at this point. Also, if there's anybody watching on Zoom, you are to, or YouTube or live stream or whatever it is, you are to stop watching at this time. All right, counsel?
And the second is pursuant to MCL 76611B, I'd like to introduce into evidence a copy of the MSP lab report, which will reflect that the defendant's blood came back to test for 0.165 grams of alcohol per 100 milliliters of blood.
All right, and Ms. Tucker, any response?
No objection for exam purposes.
Okay,
And for our first witness, we call Officer Morgan Gardaki.
okay, all right, thank you. And then, if you can grab. All right, good afternoon. Please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. And I will note that the witness approached with what looks to be a police report and it is turned upside down. Is that correct?
Yes.
Okay. And so do not reference that unless you are requested to reference that for recollection purposes or some other purpose. And if you could please, for the record, state and spell your first and last names, please.
Morgan, Morgen, Gardocki, Gardocki.
All right, and counsel, you may proceed.
Thank you. Officer Gardaki, are you currently employed?
Yes, I am.
Who's your employer?
City of Wyandotte,
And in what capacity are you employed there?
police officer.
Were you employed in that capacity as a police officer on October 30th, 2021?
Yes, I was.
Did you work that day?
Yes, I did.
And did you work that day by yourself or with a partner?
I was by myself.
And on that day, did you work in full uniform or modified uniform?
Full uniform.
Did you operate a scout vehicle or did you work foot patrol?
I was in a scout vehicle.
Was your scout vehicle fully marked or semi-marked?
Fully marked.
And on October 30th, 2021, did your duties as a police officer take you at or near the station of Grove Street and Biddle Avenue?
Yes, it did.
Is that located in the city of Wyandotte, County of Wayne?
Yes, it is.
What took you to that location or near that location?
I was advised by dispatch that there was a BOL, or be on the lookout for, a reckless vehicle in that area.
And what type of vehicle were you on the lookout for?
A white sedan.
And when you made that location, did you observe a white sedan?
Yes.
And did you approach the white sedan?
Yes, I did.
And what happened during that interaction?
I approached the driver door and I made contact with a male who was later identified as Mr. Brown. I began speaking to Mr. Brown about what he was doing at the location.
Okay, before we get into that, where was Mr. Brown in regards to this vehicle?
Mr. Brown was seated in the driver's seat.
Okay, was there anybody else inside of this vehicle?
No, it was not.
And what began when, were your lights or sirens initiated during this contact?
My emergency lights were on.
And how did you initially make contact with them? Did you approach the driver's seat?
I approached the driver door. Yeah.
And what happened next?
I began speaking to him, asking him about what he was doing at the location.
And what happened next?
Mr. Brown replied that he had ran out of gas, and he then attempted to start the vehicle, and it did not start because there was no gas, and he was beginning to point to me.
And do you see Mr. Brown here in the courtroom today?
Yes, I do.
Can you please point to him and point out something he's wearing?
Yeah, he's sitting in the desk on my left wearing a green shirt.
Your Honor, please let the record reflect the witness has pointed to and identified the defendant.
The record will so reflect, barring any objection from counsel.
No objection.
All right, thank you.
And what happened next?
While speaking to the male, he was on the phone with a female, and I asked him to hang up the phone and step out of the vehicle because I smelled the odor of alcohol intoxicants coming from inside the vehicle.
And do you know where specific in the vehicle the odor of intoxicants was coming from?
No, I do not.
So what happened next?
I asked Mr. Brown to step out of the vehicle, and he began rolling up his window.
Why did you ask him out of the vehicle?
At that time, I had not identified Mr. Brown. However, I could smell the odor of alcohol intoxicants, so I was going to further my OWI investigation
And what was the reason you were there again?
for a reckless driving.
And what happened next after you asked him to step out of the vehicle?
Mr. Brown began rolling up his window, so I manually opened his door so that he could not shut me out, or if the car magically started, he could take off, so I opened the door.
And what happened next?
Mr. Brown refused to get out after being asked several times.
Do you recall how many times you asked him to step out of the vehicle?
It was more than once, but I do not recall the exact amount.
And what happened after that?
Mr. Brown then exited the vehicle and was arguing with me. However, he then retreated back into the vehicle.
What was he saying during the argument?
I cannot recall direct quotes at this time.
And did you shut the door?
I did not shut the door.
Did he shut the door?
He attempted to shut the door, yes. However, I was holding the door open.
And what happened next?
Next, Officer Mack arrived on scene. And once I had another officer there, Mr. Brown exited the vehicle and stepped in front of the rear passenger door.
Okay, what happened after that?
Mr. Brown's behavior was loud, boisterous. He was cursing. He was waving his hands around, and I advised him if he did not calm down, that he would be placed under arrest for disorderly conduct.
What happened after that?
Mr. Brown's behavior did not change, and Officer Mack and I then turned Mr. Brown around to face the vehicle and attempted to place him under arrest while giving him verbal commands that he was under arrest and to place his hands behind his back.
Why was he under arrest?
Because his behavior continued to be disorderly.
And then what happened after that?
Mr. Brown continued to resist arrest as officers were trying to gain custody of his arms, and he pulled them to his chest to resist against officers.
Did he do anything else to attempt to resist you guys?
It was just the tensing of his arms and pulling them to his chest.
And which officer specifically was he tensing his arms against?
I believe I was on the left side of his body with his left arm, and Officer Mack was on the right side of his body with his right arm. And to my belief, he was tensing both of his arms, but I can only testify that he was tensing his left arm.
And you know what Officer Mack was doing during this interaction?
Officer Mack was attempting to get control of his right arm and place it behind him to get out of the bag.
And why was he attempting to do it in that manner?
Because he was effecting an arrest.
And was the defendant complying with your guys' commands?
He was not.
And what else transpired, if anything?
Mr. Brown was placed under arrest and eventually successfully detained in handcuffs behind the back and placed in the rear of my patrol vehicle.
And during that arrest, did he make any specific statements to you?
Yes, while he was in the back of my patrol vehicle, he stated something to the effect of hoping that somebody would shoot me in the head.
Well, do you recall exactly what the defendant said to you?
I would have to refer to my report.
Would that help refresh your recollection?
Yes, it would.
Okay, go ahead, please refer to your report, refresh your recollection. Once you've done that, flip your paper back downside.
I refresh my recollection.
And do you recall the question?
Yes.
And go ahead and answer it.
Mr. Brown stated, I hope someone shoots you in your head, bitch.
Who did he say that to?
I was the only other person in the vehicle, so I assumed he stated it towards me.
And were you able to complete a OWI investigation?
Due to his behavior, I was not able to conduct SFSTs.
Right. And what happened after the arrest?
Mr. Brown was transported to the Wyandotte Police Station to be booked and processed.
Was he transported to the hospital at any point?
Yes,
Who transported the defendant to the hospital?
I transported the defendant.
And what happened there?
At the hospital, we were effecting a search warrant blood draw for alcohol in Mr. Brown's system.
It was a search warrant signed by a judge.
I believe so, yes.
And what transpired at the hospital?
As the nurse was preparing to draw Mr. Brown's blood due to his behavior, he was already handcuffed to the hospital bed. However, once the nurse was preparing to execute the blood draw, his behavior and mannerisms were keeping the nurse from using a needle to poke in his arm. So officers had to hold him down so he was not moving and would not hurt the nursing staff.
And which officers had to hold him down?
I do not remember specifically who by name was there from the Wyandotte Police Department. However, I know that there was 4 Wyandotte Police Department members there. And there were also 2 hospital security staff and a nurse that helped us hold him down.
And did you observe this?
Yes, I did.
And did you observe the nurse conduct a blood draw?
Yes, I did.
And did you observe whether or not this was used using an MSP blood kit?
Yes, it was.
And did you take possession of the blood draw?
Yes, I did.
And did you place that into evidence afterwards?
Yes, it was.
And did the defendant further obstruct, assault, or resist you during that interactions?
After the blood draw, he did not.
Okay. Nothing further.
Okay. And cross-examination.
Good afternoon, Officer Gardecki.
And counsel, if you'd like to adjust the podium so you don't have to twist your waist, that's fine too, or whatever's comfortable for you.
So back on October 30th of 2021, how long had you been with the city going back?
It had been just over a year now.
Okay. And had you been a police officer before then?
No, I had not.
And about how many people did you see, or I should say, on a daily basis, who are under the influence?
I can't give an exact number for how many people I deal with that are intoxicated.
More than one a day?
I
Can't give.
can't state that, no.
Okay. And on that night, you were on patrol, correct?
Yes,
And by yourself.
yes,
And you stated that you received a dispatch?
yes, it was a POL.
Okay, be on the lookout.
Yes,
Okay. And before you approached Mr. Brown, did you speak to anyone else?
yes, I did.
Okay. And do you remember who that was?
I don't recall his name. But it is in my police report.
Okay. Would you like to refresh your recollection?
Yes, I would.
Okay, go ahead.
I do the best of my recollection.
Okay, and what was the name of that individual?
That male's name was Joseph Simeon Daly.
Okay, and
I'm sorry, I need you to spell first, middle, and last names, please, for the record.
Can I read it from my police report?
Any objection, counsel?
No objection.
Yes, you sure may.
Joseph, Joseph, Simeon, Simeon, Daly, Daly.
Okay, thank you.
And you came into contact with Mr. Daly before Mr. Brown, correct?
Correct.
Okay. And where did you see Mr. Daly at?
Mr. Daly was on Biddle near Forest Street.
Okay, and what was your reason for speaking to Mr. Daly?
While looking for the white sedan in the area that was driving recklessly that I was informed about, Mr. Daly was stopped in traffic with his hazards on Biddle.
Was Mr. Daly the person that called 911?
I do not know.
Did Mr. Daly point Mr. Brown out to you?
Yes, he did.
Okay. And so you then went over to Mr. Brown
Yes, I did.
and you put on your lights.
My lights that were on previously from stopping behind Mr. Daly.
Okay. And you approached Mr. Brown on the driver's side?
Correct.
Okay.
Oh, sorry.
And did Mr. Brown roll down his window?
I can't recall if the window was already down or if he rolled it down for me.
Okay. And you asked him what was he doing over there?
Yes,
Was he not supposed to be there?
the area is specifically an industrial area in where his vehicle was pointing towards, and all businesses in that area were closed at that time of night.
Okay, thank you. And he told you that his car had ran out of gas, correct?
Yes, it did.
And he indicated to you by turning on the ignition that it was out of gas, correct?
Yes, correct.
Okay. And you said he was on the phone with someone at the time, correct?
Yes,
Okay. Did he tell you that his girlfriend was on the way to bring him gas?
Yes,
Uh, you said that you smelled the intoxicants.
correct.
Okay. Did you find anything in the vehicle?
I do not recall.
Okay. When Mr. Brown got out, did you smell intoxicants on him?
I do not recall.
Okay. Were you the one that did the inventory search?
I do not believe so.
Do you know of any alcohol was found in that vehicle?
Not that I know of.
And you said you directed Mr. Brown to get out of the vehicle because you smelled intoxicants, correct?
Correct.
And Mr. Brown proceeded to roll up his window.
Yes.
Okay, and you opened his door.
Yes.
Okay. Did you give him a chance to get out before you opened that door?
No.
Okay. And did Mr. Brown get out after that?
After I opened it,
After you opened his door, yes.
not immediately, no.
Okay. About how long did it take for Mr. Brown to get out that vehicle?
I do not recall the extent of time, but I asked him multiple times.
Okay, but he ended up getting out, correct?
Actually, yes.
Okay. And you said Mr. Brown when he got out, was yelling at you?
Yes.
Okay. And you at that point were still by yourself? Or had Officer Mack shown up?
I believe Officer Mack was approaching the vehicle when Mr. Brown finally did exit the vehicle.
Okay. And you're saying Mr. Brown then got back in the vehicle?
No. Mr. Brown, when Officer Mack was walking up to the vehicle, Mr. Brown exited the vehicle for the last time.
Okay, so let's stop right there. So Mr. Brown got out of the vehicle twice?
Correct.
Okay, and the first time when you instructed him to get out of the vehicle?
Not immediately after being instructed. I instructed him to exit the vehicle. He would not. He then exited the vehicle for a moment to stand in front of the driver's door and then retreated back into the vehicle.
Okay, so then he came back out once Officer Mack came.
Was arriving, yes.
Okay, thank you. And you stated that you instructed Mr. Brown to stop being disorderly?
Correct.
And Mr. Brown refused?
Yes.
Okay, and you then arrested Mr. Brown?
Yes, I did.
Did you tell Mr. Brown he was under arrest?
I believe so, yes.
Did you tell Mr. Brown to turn around, or did you spin him around and start arresting him?
I believe I cannot recall exactly whether I told him or hands on him or if it was vice versa.
Okay. And at that point, both you and Officer Mack were placing handcuffs on Mr. Brown, correct?
Correct.
Okay. And you said you can only testify to your Mr. Brown's left hand, correct?
Correct.
And you were saying that he was tensing up?
Yes.
Okay. But the two of you did get him secured, correct?
Yes.
You did get him to the police station, correct? Okay. And at some point you got him to the hospital?
Yes.
Okay. It was just you and 3 other officers?
Correct.
Okay. And did Mr. Brown refuse a breathalyzer?
Yes, he did.
Okay. And did he refuse for you to draw his blood there? Or I'm sorry, do you guys draw blood at the police station?
No, we do not.
Okay. So you had to take him to the hospital?
Yes.
Okay. And when you and the other officers got to the hospital, you immediately handcuffed him, correct?
I believe so, yeah.
Okay. And that was to a stretcher, correct?
Yes.
Okay. So
Oh my. Ladies and gentlemen, we have been raided by Colin. And we have at least one person, Steven Sky Reading, who has snuck in with Colin. I want to thank everybody who has snuck in with Colin. And I want to say, this is your obligatory Colin pause. Just to give you a rundown of what's going on, we're watching Judge DiSanto from January the 22nd, 2026. This is a preliminary examination, a probable cause hearing, something like that. The guy was arrested, pitched a fit, told the officer he hopes the officer gets shot in the head. And right now, the defense lawyer is questioning the officer on the stand. This, ladies and gentlemen, has been your quick rundown and catch up and your obligatory Colin pause. Now back to the program already in progress.
he couldn't go anywhere, right?
No.
Okay. And the nurse drew his blood, correct?
Yes.
And you said it took four officers, 2 security guards from the hospital, and a nurse to hold him down to draw his blood.
Correct.
Was he kicking?
I can't recall if he was kicking his feet.
Okay. Was he trying to get out of the bed?
I can't recall if he was trying to get out of the bed.
Okay. But the blood was drawn, correct?
Yes.
And he was already handcuffed, correct?
Yes.
Okay. No other question here.
Okay, thank you. Any redirect?
Yeah, please. So, did the defendant refuse a blood test?
Yes, he did.
Is that why you obtained a signed search warrant from the judge?
Yes.
Can you demonstrate to the judge how he tensed his arms when you were attempting to arrest him? Is it possible?
I don't understand.
So you indicated that during the arrest, the defendant tensed. Did he tense his arms?
Yes, he tensed his arms.
Is that how he resisted you during this interaction?
I wouldn't say that the tensing of his arms was the resisting factor. I believe it was when he tried to pull his arms away from the officers and pull them to his chest.
Understood. Nothing further.
Okay. Any further cross?
No, Your Honor.
I thank you. All right. Any further, actually, let me sit down, officer. Thank you very much. Do not discuss your testimony with anybody. Any further witnesses for the people?
No, thank you.
Any witnesses for the defense?
No, Your Honor.
Okay. And Mr. Mohammed?
Judge, I believe that testimony requests a question of facts. I'm going to motion for a final arrest pro and reserve any arguments.
Right. And Ms. Tucker?
Your Honor, at the one count of resisting arrest, as Officer Gardecki, I'm sorry, mispronounce his name, said there is a question of fact for a trial of fact, Your Honor, but there are 2 counts of police officers assaulting, resisting, obstructing, with the other one being PO, Officer Mack. Your Honor, Officer Gardecki testified that he couldn't testify as to whether Mr. Brown resisted or obstructed Officer Mack because he could only testify to what he did, Mr. Brown did to him, Your Honor. There is no testimony that at the hospital, Officer Mack was there, just, 4 other officers. So for that second count of resisting arrest and resisting obstructing, Your Honor, I ask that it be dismissed.
Okay. And any response, Mr. Mohammed?
Judge, the officer indicated that it took both of them to arrest the defendant. They were both struggling from what I could gather from the witness's testimony. and that the defendant was resisting both officers. He wasn't nice to one officer and letting the other conduct an arrest. So it just seemed to me from the totality of the circumstances in the testimony that the defendant was resisting both officers during the arrest. And so I believe it's a question of fact.
Okay. The court heard testimony from Officer Gardaki. Officer Gardaki testified that he had to instruct Mr. Brown on a number of occasions to exit the vehicle. And when he first ordered him to exit the vehicle, Mr. Brown rolled up the window, which is why Officer Gardaki indicated he manually opened the defendant's door. Further, that the defendant continued to refuse to get out of the vehicle until a second officer arrived on scene. Officer Gardaki testified that Mr. Brown tensed up, pulled his arm to chest as to resist, and Officer Gardaki indicated that he was on the left side of the defendant's body with the left arm, and that that's what he experienced. He further testified that he observed Officer Mack attempting to place the right hand behind defendant's back to arrest the defendant, and the defendant was not following commands, and that it appeared as though there was difficulty in getting Mr. Brown's right arm to the back so that he could be placed under arrest. So based upon the evidence that this court has heard at this point, the court does find it's a question of fact. The court also finds that based upon the testimony this court has heard, that an offense not cognizable by the district court has been committed, and that there's probable cause to believe that defendant committed that offense. The court's going to bind the defendant over to circuit court for further proceedings. You are to appear in circuit court, sir, on January 29th at 9:00 in the morning on the charges in the complaint. Bond and conditions are continued.
Your Honor, Mr. Brown would like me to address it.
All right, just one moment. All right, defendant or bond is currently $10,000, 10% bond. The prior bond had been revoked on November 7th, 2022. On December 9th, defendant was in custody. At this time, the court ordered $25,000, 10% bond, GPS tether through the Wayne County Jail. That was to be concurrent with the current tether order at that time on his matter in the 36th District Court. And that defendant shall not operate a motor vehicle and possess or consume any alcohol or drugs that are not prescribed. And counsel?
Yes, Your Honor. That matter at the 36th District Court has been bound over on just the felon in possession ammunition. The felonious assault was dismissed at the preliminary examination, Your Honor. He has the personal bond in that case. This case is from 2021, Your Honor. So we're asking, he needs to get out, and he needs to get himself together and get his get his affairs in order. So we're asking if it can mirror his personal bond there along with the GPS tether, even house arrest, Your Honor. This case, is older than the case that he currently has at the circuit court, to which, it's a little more serious, but he has a personal bond there, Your Honor. We're asking if at this point, he's been in custody the entire time, if it can be reduced to a personal bond with the GPS tether, house arrest, if not something that's even lower than 25,000, 10%.
So, counsel, you're indicating that felony firearm, that's the charge that your client was bound over on in 36th District Court, correct?
He was, the felonious assault was dismissed. He was bound
Felon in possession.
the possession.
Okay, and, all right, and so you just indicated that felon in possession is a more serious charge than assaulting, resisting, obstructing an officer? Is that what you just stated?
Yes, Your Honor, tense enough. is considered resisting, and that's enough to, by a probable cause standard for resisting arrest. Your Honor, he did not, take a swing at the officers. Yeah, his mouth was running, but Your Honor, again, it's completely different than, weapons possession by a prohibited person. And ammunition, by a prohibited person.
And so was the exam held?
It was held, Your Honor.
And did the victim on the felonious assault appear in court?
No.
Okay, so it was dismissed because they did not have a complaining witness whereby to proceed, not because there wasn't enough evidence after testimony, correct?
That is correct.
Okay. And so,
Officers did testify.
all right, and so the court will, they testified as to the felonious assault, or they testified as to the felon in possession?
They testified as to the felon in possession.
Okay.
The reason why they went to the house.
All right, well then,
Assault.
okay, then also, just for the record, this is a 2021 case, and just now, coming to exam because your client failed to appear for the arraignment October 27th of 2022. And then a warrant had been issued, and when your client was in custody at the Wayne County Jail, presumably for the matter from 36th District Court, that is when this matter started to proceed on. So,
Your Honor, if he missed that arraignment, was he given that arraignment date, Your Honor?
we would have sent, yes, we sent notice, October 7th, we sent notice to his address. We sure did.
What was the address of the
On Floyd Street. Well, let me see here. I mean, we can't track people down all the time wherever they move. And if you don't change your address, sir, we have no way to know that you have relocated. So, I'm sorry?
I may as well for the.
Just, I'm going to give you an opportunity, Mr. Mohammed. What's that?
I was expecting the bail bondsman to inform me as well of the court date, which I dealt with him after that here recent. You know, I had contacted the Secretary of State, he called one, I just hadn't got around to making the appointment with you guys. I do accept responsibility for that, but
Okay.
I was not made aware of the court date. Well, I definitely would show up. As I do all my.
Well, you were aware. You just indicated you were aware. You just hadn't made it around to get over here. So, all right, Mr. Mohammed.
Judge, in light of the testimony in the court finding that there's probable cause in this case, and also I was not present for the arraignment, I think the court should modify the bond, but it should be 25,000 cash with no 10%. This isn't a case where an individual just flared their arms. He's also charged with operating while intoxicated, driving with a suspended license. This is an individual who has a clear disregard for the law, and that's clearly shown from his other case in Detroit, where he's picked up another case. So I think bond should be amended, and it should be 25,000. He didn't just say simple words. He said, "I hope someone shoots you in your head, bitch," to a police officer. This is the same defendant that was previously convicted for homicide in the second degree. So words do have meaning, especially in situations where people are acting in this type of way. The police were responding in this case to a reckless driver in a white sedan, and they located that person. And they conducted an investigation, and that's exactly what they were doing. And it showed that he was intoxicated. And his conduct afterwards showed why he's charged with 2 additional felonies. So I do think bond should be amended, and it should be 25,000 cash, and that's the people's position.
Your Honor, he served his debt to society, and he did all of his time in prison for his second degree murder. Again, him saying, "I hope someone blow your head off," bitch. He didn't say I was going to blow your head off. Again, they're words. He didn't put no words to actions. So words, they're words. That's it, Your Honor.
And Judge,
So to increase it from the to remove the 10% because of his words and because He's, he has a past criminal history. He served his debt to society. That criminal history is now on there as that second habitual notice on there, Your Honor. So I ask to not amend that to take off the 10%. He has done nothing other than miss one court date.
And Judge, if I may, he did. I'm not going to disagree that whether or not he served his time. Nonetheless, it doesn't appear he's changed his ways in regards to the law. And my concern is the safety of the public. And I want to ensure that the public is protected. And this is how I do that. And things we take into consideration is an individual's past and whether or not they're going to commit a crime again. And it seems he may be set in his ways. I hope he changes. I hope we never get a case with him again. But if it's a reoccurring theme, we have to take proactive steps to address it and protect the public. And that's why I'm requesting that the $25,000 be purely cash. Thank you.
Okay. And so what the court will note as well is that in this instance that Mr. Brown was charged with 2 counts of resisting, obstructing an officer, driving while license suspended, operating while intoxicated, and then the no insurance as well. The court will also note by way of procedurally that notice was mailed to the last known address of Mr. Brown, as the court did indicate, as Mr. Brown stated that he may not have been at that address. The court did indicate that it is an individual's responsibility to change their address with the appropriate agencies so that if they need to be contacted, they can be contacted. This was not done. This is the address that the court had for Mr. Brown, even through the Secretary of State. That's what the court had for Mr. Brown's address at the time that it sent notice in the mail. Mr. Brown, and I'm actually looking at a copy of the Secretary of State record that shows the Floyd address, even October of 2021. And the court will indicate as well that Mr. Brown did not show up, did not appear. And the court will also note that it did take into consideration Mr. Brown's failure to appear previously and that he was in custody on yet another charge in the 36th District Court. And the court will take into consideration that Mr. Brown was not bound over on the felonious assault, but the court also is taking into consideration that that's not because there was a lack of evidence after testimony, but that's because the victim did not appear in that matter. The court will also note that Mr. Brown has a prior OWI conviction from 2017, and while today is 2026, this offense occurred in 2021. And the court will also state that Mr. Brown has continued to violate the law since that time as well. There is an obligation to protect the public. There's also additional warrants, it appears, for Mr. Brown and his inability to appear in court. Let me just confirm that this is Mr. Brown. This is, were you on probation in Livonia, sir?
Some years back, yes.
Yes, well, there was a probation violation that you failed to appear for. That was on the OWI, or the impaired. Then the warrant was out of here. So you still have the warrant out of the 16th District Court, unless you took care of that while you were in custody in the Wayne County Jail. Did you take care of that while you were in custody in the Wayne County Jail?
No.
Okay, so based upon this,
2 days community service.
I'm sorry?
That's for 2 days of community service.
Well, whatever it's for, sir, when you're ordered to appear in court, you're required to appear in court. And this has been a number of years that matter has been pending, and you have not taken care of that issue. And so to ensure that you're going to appear in court and to ensure the protection of the public, the court finds that the bond is appropriate. It's unfortunate that the 36th District Court thought that you did not have a serious enough offense to warrant a cash bond, but in any event, whether they ordered a personal bond or not, the court's not taken that into consideration. The court has ordered $25,000 10% bond. The court is going to continue that bond as well as the conditions.
Thank you.
Thank you. Thank you. Let's go off the record.
And Robert Leon Weaver.
He wants to talk to you, that's how I'll talk to him.
That's not the way it works. Tell me
Explain
that.
it to him.
Okay.
Got
Okay.
that.
What is it he wants to, Robert?
He is claiming that he should not be revoked off probation because he was never guilty of anything, and that he doesn't understand why. And he has told me
Oh, boy.
he's fired me multiple times.
Okay.
About this.
Yeah, this is Edgar Pons.
Oh, he was found competent, I think, but he's not very rational and doesn't seem to. So,
Bring Robert Weaver in, please. Yes, sir. Thank you. Huh?
so when they reevaluate.
It just happened last month.
Oh, then I will shoot a silent to you. If you didn't speak to me,
No, this is dated December 3rd.
yeah, sign up parts.
No, we can't be doing monthly evaluations.
I agree, Your Honor.
Come on down. You're Robert Weaver? You're Mr. Weaver? Yeah, I recognize you.
Yeah.
Robert Weaver. Here in 24 CR 121, Mr. West is your attorney and the state's attorney here and the probation officer is here. There is a first amended motion to revoke probation that has been filed in your case, Mr. Weaver. And it states, no, it's a motion to revoke probation. You certainly are, though, experiencing a habeas corpus right now because here you are. Your body is before the court, and that's what that essentially means. You are on probation for 10 years for arson as of May 6th of 2024. And there are 7 allegations of violations, which include committing the offenses of public intoxication, obstruction or retaliation. That's all in May of 2024. One of those is 3 days after you were released. You were placed on probation and released. Within 3 days, you were committing the offense of public intoxication, according to this. And then 8 days later, you were charged with the offense of obstruction and failed to report to the probation office as directed on May of 2024, which was the day you were placed on probation. You failed to never become intoxicated by being intoxicated. Then there are 2 additional allegations which allege that you committed the offense of assault causing bodily injury on May 2nd, 2025 in Harris County, Texas. And also on that date, you committed the offense of criminal mischief. So if one or more of these allegations of violations have been proven, then by a preponderance of the evidence or greater, your probation can be revoked and you can be sentenced up to 10 years in prison. Do you understand what you're facing here, Mr. Weaver?
I do.
Okay. Mr. West is your attorney here. What are we doing today, Mr. West? Huh?
I do need Mr. West.
He's here if you need him. If you want to represent yourself, is that what you want to do? You can do that.
Of course.
That's not a wise thing to do, but he has been appointed to help you if you need it. Do you understand? He's going to be right here and he's going to be ready, willing, and able. You want to represent yourself? That is your decision. But historically, people who represent themselves fail miserably if they are not familiar with the rules of evidence, the rules of procedure, the rules of the penal code, and have experience and training in this. But you're a grown up, you're an adult. If you want to represent yourself, you may do that. Is that what you want to do?
Yes, sir.
Then are you making that decision?
If it
Well, then-
pleases the court.
Don't interrupt me because we both can't speak at the same time. Then she can't take it down, but you'll have a chance to be heard fully. Okay. And if you want to represent yourself, are you doing that after thinking long and hard about it? And you've had a chance to see, I guess, and talk with Mr. West, haven't you? Yes,
Sir.
Okay. And after those discussions, is that what you want to do as an adult, clear-headed, thinking, a competent person? Do you want to represent yourself in this matter?
Yes, sir, Your Honor.
Okay, you will be allowed to do that. Mr. West, though, will be right there if you need to refer and get any help whatsoever. He's your lifeline. He's within 10 feet of you. Okay?
I understand.
All right. And do you waive a formal reading of this first amended motion to revoke probation? And can we proceed in a summary fashion?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm that any statements you might make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? If you make any statements, will they be the truth?
Yes, sir.
Okay, lower your hand. In summary, sir, this first amended motion to revoke probation alleges that on May 6th, 2024, in this court, you were sentenced by this court, me, to 10 years in prison, and that was suspended. I placed you on regular probation for 10 years for the second-degree felony of arson. Is all of that true?
May I defend myself?
Yeah. Well, is all of that true?
In my own defense, my attorney was fired preceding that trial. I spoke to him briefly in December the 18th, approximately, and I relieved him of his duty.
Maybe this helps your recollection here. I'm going to show you some items that are called written plea admonishments dated March 25th of 2024. And was that Don Dusler?
Yes,
Was
sir.
the attorney? Here, look at those. Do you recognize that? Is that your signature?
Don't have my reading glasses. I do not have my reading glasses.
You don't go without them? Here, borrow his. Borrow his. Thank you. Those are reading glasses.
These are not legally binding signatures, Your Honor, because
Do you recognize those as your signature?
Dusler actually presented himself and he was dismissed.
Okay.
Is that your signature right there?
Okay, here's what we're going to do. I see where this is.
Right here, no, that-
I see where this is headed. We're going to have a hearing on
Yes,
this. Okay. And when are we picking a jury today? We're doing it in the morning. What are we doing this afternoon? Here. What do we have set for this afternoon? Settings. Can we do it this afternoon? I mean, it's set for today. Can we bring him back this afternoon? And can the state be ready to make its presentation? Because
I can do the administrative.
I'm going to
do
state,
the new office.
I understand. I will just enter denials on each of these because I see where we're headed. The court will also note and put into the record that the defendant was evaluated on or about December 3rd of 2025 by Dr. Ed Rapon, licensed psychiatrist, as the court requested that Dr. Rapon evaluate the defendant for competency. The report was prepared and it was placed into the record at a hearing on January 5th of 2026. And the court found, based upon Dr. Rapon's evaluation, that the defendant is competent to proceed to a resolution of his legal issues. And he does have a mood disorder, which is currently being treated, and he is stable while taking his medications properly. And
No, on my medication.
why not?
I lost it when I was on vacation from May 3rd, 2023 or whatever it is.
No, this states as of December 3rd, 2025, this states that you were on medication at this time and you are not in need of involuntary psychiatric treatment or intervention, and is aware that your next court date is early January 2026, which we had to postpone. You were able to accurately identify your court-appointed attorney's name, and in your mental state, you were able to follow legal proceedings and would be able to conduct yourself appropriately in a court of law only if you choose to do so, this states. And you do possess sufficient ability to communicate with an attorney, and you have a reasonable degree of rational understanding of the preparation of defense. You have made your decision voluntarily and knowingly, and you are competent to decide whether to represent yourself or not. It's not a wise decision to do that, but you are like competent adults, you are allowed to make your own decision, whether it's a wise one or a poor one. So we will have a hearing this afternoon on this, and just be prepared. I ask the state to be ready to make its presentment. And Mr. West, I'm going to ask you if you'd be so kind to be present, and we're going to do it at 1:30. Yes, sir. Be present. And if he needs any help from you, then he can speak with you.
Yes.
All right. That is all. Thank you.
That's fair.
Thank you.
We'll need to pull that camera on the
Witness,
lawyer's tables.
do you want the witness camera on?
Have a seat, sir. Thank you. With Mr. West, your attorney, right here. There you go. Thank you. Yeah, right there. Sit.
Oh, no, I'm not sure.
This is habeas corpus, bringing the body forth. You have been brought forth in front of the court. That's what you wanted, to be live and in person.
Accidental fire cannot be malicious.
Yeah, I can't hear you.
An accidental fire cannot be malicious.
I understand.
My affidavit cannot be used to.
Okay. All right. That's not.
So
You're going to get a chance to speak. Court gets to speak, though, and I'm kind of the manager of the proceedings, so that we can keep it on track. Let me make some announcements here. We are calling cause number 24 CR121, the state of Texas versus Robert Leon Weaver, and you are Mr. Weaver, and you are here with Mr. West, your attorney.
Okay. I'm been removed as.
Oh, that's right. That's right. He's going to represent himself.
Yes, yes.
And Mr. West is sitting by. He is there for you to refer to at any time you want. But you, Mr. Weaver, are insisting to represent yourself in this, correct?
If it pleases the court.
All right. It does. I just am concerned about your abilities in handling matters of court that a person who graduated from law school and has experience like Mr. West is able to provide. Because even though you are allowed to represent yourself, you still have to follow all the rules that all judges and lawyers have to follow. And that is in this court, primarily the penal code and the code of criminal procedure and the rules of evidence. And a lot of times people who represent themselves who aren't familiar with those are at a disadvantage. I've talked to you a little bit about that. You've had a chance to think about it. Is it your insistence to continue to wish and represent yourself at this hearing? That's what you want. Correct or not?
Yes, sir.
Okay. At any time you change your mind, Mr. West is right there 5 feet from you. You can refer to him or ask him in questions as well if you want some guidance or clarification, because I'm not allowed to be able to help you on this. That's for your lawyers. And the DA's office is not going to help you. He represents the state of Texas, not you. But Mr. West has been appointed to represent you, and you are making this decision to self-represent or represent yourself at this hearing. You're doing this voluntarily and based upon reflection and consideration of it. Is that true? You've thought about it, and this is...
Yes, sir.
Okay. Do you need any additional time to think about it?
I do not.
Okay. We'll move forward then. All right. There is a first amended motion to revoke probation, sir, that has been filed. And also, please raise your right hand. At any time you make any statements during this hearing, do you promise that whatever you state will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand. In summary, this first amended motion to revoke probation, it was filed September 3rd of 2025. It states that on May 6th, 2024, in this criminal district court of Jefferson County, Texas, you, Robert Leon Weaver, was sentenced to 10 years in prison, and that was suspended, and you were placed on regular probation for 10 years for the second-degree felony of arson. Is that true or not true?
I disagree.
You disagree. Okay, you can do that, and the state has the obligation to prove. Number one allegation states...
Well, just take the proceeding only on count 3.
3.
Yes, sir.
Number 3, allegation 3 states you failed to report to the Jefferson County Community Supervision and Corrections Department, the probation, in other words, the probation department. It says failed to report since you were placed on probation on May 6th, 2024. You never reported to probation as required by your probation order that the court placed you under and signed based upon your plea of your entry of a plea in this court earlier, and you never reported, and that was since May 6th, 2024, which is over a year and a half. Is that true or untrue?
With my affidavit being used solely to prosecute or
No, is it true or untrue?
That is untrue.
Okay, that's entered into the record untrue. That's all you need to say. The obligation is on the state of Texas to prove these allegations. And Mr. Laird, on behalf of the District Attorney's Office for Jefferson County, Texas, you may call your witnesses.
Judge, first ask the court to take judicial notice of all the documents in this court file, in this file number.
Yes, sir. It shall.
And I would call Troy Robinson to the stand. So did I ask you to fingerprint someone today?
Yes, sir, you did.
Who did I ask you to fingerprint?
You can see the card.
Was it a Robert Weaver?
That's correct, Robert Reed.
And you see that individual in the courtroom today?
I do.
And can you describe something he's wearing?
Yeah, a red jumpsuit.
Record reflect he's identified the defendant.
Yes, it will.
So let me show you what's marked as State's Exhibit 1. Do you recognize this?
Yes, I do.
What is that?
This is a fingerprint.
Okay, and what fingerprint card of who?
Robert Weaver.
And is that the Robert Weaver that you just identified in the courtroom today?
It is.
And is that the ink print that you took from Mr. Weaver earlier?
That is correct. It is the instrument that I took earlier today, signed by me on 1/26/26 at 1:30 p.m.
I'll tender State's Exhibit 1. Says your fingerprint on it. Any objections?
Is there any objection to that fingerprint card being submitted by the state into evidence, Mr. Weaver? No objection?
Well, yes, sir.
What?
May I address the witness?
Briefly?
Okay. And what is the likelihood that you'll be able to run a background check statewide, nationwide, worldwide, without my Texas Department of Transportation number, Texas license number, which is not on the card, correct?
It's not on the card, no.
It's not.
No, it is not.
Is that why you said you were going to take the fingerprint from me so that you could run a background check? Your fault.
No, sir.
Anything else?
What is a probability with today's technological advancements that a fingerprint could be impersonated by possibly plastic or an engraving? Is that possible?
Are you asking, can the fingerprint be copied into a plastic or into some type of engraving?
Yes, sir.
Yeah, that's possible.
Anything else?
Nothing else.
Okay, go ahead.
Then State's 1. This is the same individual who took this fingerprint from yourself. Is that correct?
That is correct.
Any objection to that?
May I enter my Texas Department of
Any objection to it?
Does this have this individual earlier you took? Did you ask him for a social security number?
Yes,
And his date of birth?
I did.
And did he also, did he sign this?
That is correct. There is no spot on the fingerprint card for the Texas State CDL number that he is attempting to give me.
Okay. But it does have his social security number on it.
Yes,
So
sir.
he gave you.
Any objection?
was this
No, yes. Is there an objection? What is the objection, sir?
was it not taken to run a background check?
No, that's, you can cross-examine him here in a minute, but you have to make an objection. That's why I urge you you've got somebody who knows what to do next to you, but you're insisting on representing yourself. When you do that, you have to follow the same rules lawyers are trained to follow. What is your objection? You can't ask him questions. It's an objection you have to make, and then I will rule on it. That's what this is right this moment. Any objection?
That with the ability to falsify these documents, I proved that maybe this should not be entered as a court document.
Okay, is that what you're saying your objection is?
That it is possible that it could be falsified information.
Okay, your objection,
It's adulterated
okay,
court document.
that's what you're saying your objection is.
That's my objection.
It is overruled. Go ahead. And State's Exhibit 1 is admitted.
Thank you, Judge. Let me show you what's marked as State's Exhibit 2, which the court has already taken judicial notice of. Do you recognize that?
I do.
And did I ask you to take State's Exhibit 2 and compare it to State's Exhibit 1 to see if the State's Exhibit 1 is the same person as State's Exhibit 2?
You did?
And did you compare that?
I did. Yes, so I took the thumbprint from State's Exhibit 1 and compared it to both thumbprints on State's Exhibit 2, and all are identical.
Now, both of these are the right thumbprint, is that correct?
That is correct.
And after comparing these, did you come to the conclusion of whether or not the person in State's Exhibit 2 is the same person as in State's Exhibit 1?
They are the same person.
So the person in State's Exhibit 2, in your opinion, is the same person you identified during the court today, Robert Leon Weaver?
That is correct.
Go ahead.
Pass the witness, Judge.
Okay. The witness is passed, and now you can ask questions, sir, of the witness.
Can I have that in layman's terms, investigator, please, sir, what was just said, please, sir? Will you state that in layman's terms? So that the court and everybody may understand.
We all, the court understands. The court understands.
What the cause 24, 38, 26 was.
At any time, sir, remember, you can ask Mr. West to help you if you are misunderstanding anything, but go ahead, ask him.
The number that you refer to is,
Okay.
yes,
Go.
Please state it in layman's terms, so I understand. I don't know every penal code in the book. You know, what that penal code is pertaining to, is it arson?
You, John, you want
Am I being charged with another crime?
sir, I do not know what other crime you'd be charged with. As far as the paperwork that was provided to me, the number represents the cause number that is filed with the court and the district clerk in reference to the case that you previously had.
You're referring to the arson?
Yes, sir.
Okay.
I believe so.
This is, just to clarify, Mr. Weaver, we are talking about the arson case only. The case of arson for which you pleaded guilty, for which you were placed on probation by this court.
Yes, sir.
That's all we're talking about.
Yes, sir.
Okay, go ahead.
Did the people at the scene of the crime wish to press charges on the defendant, Mr. Robert Weaver, for arson?
Want to object, Your Honor, that's
At the scene of the crime.
it's not relevant to this hearing. So.
Sir, that
And this investigator was not a part of that investigation.
the objection is sustained. Sir, this was, once again, this case was disposed of, for the record. The court's got to complete the record so that it is clear. You entered pleas of guilty to the indicted case, second-degree felony of arson. And that was all on March 25th of 2024. And the court, in those pleadings, you waived a trial and entered a plea voluntarily, knowingly, and intelligently, pleading guilty to the charge, the second-degree felony of arson, as indicted in this case as of January 24th, 2024 by the Jefferson County Grand Jury.
Yes, sir.
You entered a plea of guilty to that. The court found, like in most cases disposed of in this court, they're through agreed pleas of guilty, that you had through your attorney made an agreement with the state that you would be pleading guilty, sentenced to 10 years imprisonment. That imprisonment would be suspended. You would be placed on regular probation for a period of 10 years, and restitution was to be paid as a part of the probation order. All of that was entered into on March. These were documents that were signed on March 25th, 2024. Those were entered into the record when you pleaded guilty on May 6th of 2024. The court followed the recommendation and your agreement that you entered into with the state through your attorney and found you guilty beyond a reasonable doubt, sentenced you to 10 years in prison, but suspended that sentence and placed you on regular probation for 10 years. Thereafter, a motion to revoke probation was filed in this case on February 6th of last year. And among other, and it was later amended on September 3rd of 25 to allege two additional allegations of crimes, but we are only taking up in this hearing what was presented in the original motion to revoke probation, number 3, failing to report to the probation office since being placed on probation on May 6th of 2024 in violation of condition 4 of your probation order, which required you to report regularly. That's all we are dealing with, just that issue. Okay. With that in mind, go forward. You can ask a question.
Do any of those signatures match the signature that you had, detective, today?
Do you understand that question? What do you mean?
The signatures on any of those documents were light being shed on the subject of impersonation or this. If we present to the detective those documents to see if my signature, not anybody's signature, matches the ones that you have on any of those documents. Your Honor, if it pleases the court.
So I had no knowledge of anything of the case other than the scope of which I was asked is to compare the fingerprints.
Compare the fingerprint.
That is the only knowledge I have of your case.
Can you compare the signatures?
I was not asked to do that, and I did not do that.
Would you please do that for the court? If it pleases the court, Your Honor.
I am not a handwriting expert.
But you would be able to take a legally binding signature that you have and compare it to those. If you're comparing fingerprints, obvious. There are some discrepancies in this case, which as I.
What's your question? This isn't the time to make a final argument. What's your question to it?
Your Honor, can you present those documents to see if a fingerprint expert, detective, could compare those signatures with my legally binding signature to see if they match?
You mean the signatures when you entered your pleas of guilty?
Yes, sir.
That would be irrelevant. The court made its findings based upon your representations, your attorney's representations, that you had entered your plea voluntarily, knowingly, intelligently, and the court made its findings that you were the person who was pleading guilty, who was entering his plea and accepting responsibility. That was enough to find you guilty by law beyond a reasonable doubt.
Yes, Your Honor. I understand that fully.
Okay. Then you're the same person who was placed on probation. Now, the issue is, why didn't you, the person who was placed on probation in this case, report as directed to the probation office as the court ordered you, as it is alleged you never reported from the outset? That's the issue.
Okay, yes, sir. I was not on my correct medications because I was driven away at gunpoint from not only City Hall, where I may have gotten identification, or Baptist Hospital, or Genoa Spindletop on Washington 8 near the scene of the crime.
Okay. All right, just ask him some questions. If you want to take the stand and testify, you can do that here in a minute, but this is just the time to ask him any questions that you may want concerning what this witness had his involvement in. And it was just for fingerprint
Fair comparison on, Judge.
For the matters that he's testified to. Did you have any other questions for him?
We do agree though that that can be an engraving and it can be impersonated and possibly applied as false document in this case. Can be, it can, correct? And
Were you able to answer that?
No, sir.
He doesn't understand.
you already answered that.
Okay. Anything else from this man?
No, Your Honor.
No, Your Honor.
All right, you are excused, sir.
Thanks, sir.
Judge, I would like to call Mr. Robert Leon, the defendant in this case.
Come on up and take a seat.
Testify on his own.
Take a seat right here, sir. Thank you. How much time would you have credited?
I can undergo cross-examination to that day. Other witnesses.
Have a seat, please. All right. What we're going to need to do is pull that chair closer to the microphone because we know the microphone, unless you're speaking close to it, it doesn't pick up your voice. You don't want to be uncomfortable. But okay, that should be good. All right. And you can't, obviously, it's very awkward to ask yourself questions. You may make a presentation of what you want to put into the record on your behalf relevant in this case. Go ahead.
Yes, sir. I'm from Dallas, Texas, and apparently I had lost my medication. On vacation to New Orleans, passing through on the Greyhound bus back to Dallas. I was raw, so I did not have my medication. I went to City Hall.
Which city hall?
Beaumont.
Oh, okay.
And tried to register myself. And I was driven away at gunpoint by a police force in Beaumont. While looking for occupational job, I was looking for a job. I was asked to leave churches, restaurants. Somehow, my personal information had been made public, although my probation officer does not know that I'm over 21 one thing. And she does not know that I have lost my medication. I was driven away from the hospital. I'll get my prescription filled at Walgreens. Taking a victim stance, Your Honor. I was a victim in this case. And the fire was accidental. Even though my constitutional right to life, liberty, and happiness in the pursuit thereof was infringed upon it, I was in fear for my life, sir. My welfare check was sold. Food stamps card was sold. My health benefits were sold. I had no right. Janelle would not offer me any help. I could not return to Dallas. There was nothing I could do. It became bitter cold in the tropics, ranging from 109 degrees to negative 90 degrees Fahrenheit. And I was in fear for my life.
At what point in time? What date are we talking about?
Between the dates of,
You mean when this crime was committed? When this fire occurred, is that what you're talking about?
On May 3rd, in 2023, I had my visibility that shut off and I took vacation money to New Orleans. The big issue started called. And I lost my medication stomach. Yeah. And I came to Beaumont, went to City Hall, went to the hospital, was admitted, and was psychiatric. And family was gone, I believe. I stayed there for several weeks. As far as the arson and the conviction, it would have been a tragedy in my life, a tragedy being to die at such a young age with actually no legitimate health risk because of hypothermia. It would have been a tragedy to my family and my friends. I have 50 nieces and nephews, 5 brothers and sisters. And dad is still, they're both veterans. My classmates were all saluted for my class president. I tried to walk away. Really, I walked all the way to Houston, 4510 interchange. I was brought back to Jackson County.
Go ahead.
I don't believe that I would be able to survive in the jail. I've never been to prison or state jail, only jail. You know, the orders for deputy custody and bodies back.
You have
Don't hear it tonight.
you have a copy of my staff report.
I didn't hear it tonight. There you go.
Oh, thank you. Go ahead. I'm listening to you. I'm reviewing the pre-sentence the post-sentence report that was prepared by the probation office at the court's request right after you were placed on probation. Go ahead.
I was never given sobriety, field sobriety test. Most of those are misdemeanors that are your probation violations, Your Honor. Most of them, actually, to be fair, all of them actually could be concerning my criminal record. I don't have any aggravated cases, Your Honor.
Say it again.
I do not have any aggravated cases that I've been convicted of in my 50s, almost 51 years on this earth.
I'm looking at the post-sentence report. It states that you were in 2005. You were sentenced to 120 days in jail for assault on a public servant in Dallas County. Then in 2011, you were placed on 2 years deferred or unadjudicated probation in Dallas County for delivery of a controlled substance. Then in 2018, you were placed on 3 years deferred or unadjudicated probation for assault on a public servant in Dallas County, Texas. And these are all felony offenses.
Yes, sir.
Then also, let me finish. On August 27th, 2018, you were also placed on 3 years deferred or unadjudicated probation for attempting to take a weapon from a police officer in Dallas County, Texas. And in this case, so you have been placed on probation, then you were on 2 years deferred or unadjudicated for probation for delivery of a controlled substance, 3 years deferred or unadjudicated probation for assault on a public servant, 3 years deferred or unadjudicated probation for attempting to take a weapon from a peace officer. And then this case is a final conviction where you were sentenced to 10 years in prison, and that was suspended and you were placed on regular probation.
Yes, sir.
And then I'm looking at your adult, I'm not putting it into the record. In your misdemeanor, I'm looking at 11 separate misdemeanor convictions where you were sentenced to jail time since 1996 through 2018. And these were included convictions: violation of a protective order out of Dallas County, violation of a protective order in Dallas County, evading arrest or detention in Dallas County, driving while license invalid in Dallas County, criminal mischief, Dallas County, and illegal possession of marijuana, Dallas County, obstructing or resisting an executive officer out of Sacramento County, California. And in that case, you were sentenced to 204 days jail and placed on 3 years probation. Also, on that same date in Sacramento County, in 2016, you received a similar sentence for obstruction or resisting an executive officer. Then shoplifting in Denver County, Colorado, 3 days jail, 12 months probation. Assault out of Denver County, where you received 85 days jail in 2017. And assault family violence, 150 days jail out of Dallas County in 2018. So that one's 11 misdemeanor convictions, along with 5 felony dispositions, which include this regular probation of arson. That's your criminal history. That was part of the post-sentence report that was made in this case and by the probation office, and is part of the file here. Go ahead.
Dallas County Jail, Lewiston County Jail, and Frank County Court Building has ruled that there is a conspiracy against Smallot by the drug cartel and other people. Some of the times, these officers did not speak English and were not citizens of our country. Other times, like the 2 protective orders, I was not aware that my ex-girlfriend had.
Wait, hold on. On that first part, where there's threats to your life, what documentation do you have to support that?
No, the conspiracy.
No. Oh, okay.
It's in Texas Department of Corrections.
Okay. Is this how much?
Yeah.
I don't care if
Yes, sir.
that the drug cartel has a conspiracy. The drug case was under a gram of cocaine. I sat for 2 years because they would not hear my case in court. I sat for 2 years on a case.
Sometimes that can happen in those big counties.
Yes, sir. The violation of protective order. I did 8 days for misdemeanor offenses. Both of them in total. 8 days in county jail. As far as the attempt to remove a firearm from an officer, he pulled a gun on me when I was in a restaurant. He asked me to leave. I said, yes, sir. I hadn't eaten that day. I simply went there to eat. I was in the bathroom. He did not speak English, so I asked him to put his gun down. And he tased me anyway. So when the blue and white showed up, as I was leaving, he tased me while I was leaving the store. Blue and white showed up, and the taser was under my body there, inside of the restaurant. So I did approximately 4 years on that one, or I'm not sure. And then That was the Trump administration. I've never been convicted of theft in Denver County. You can't Denver Colorado. Or was that 5 feet north of the vicinity? Once again, there are falsifications. These court documents. I'd like to just have this brought to the one so I can go on the Texas Department of Corrections. And keep it pharmacy. Give me a safe place to stay. And clean clothes. And clean food and water that will sustain me. I lost 120 pounds in your care over the past approximately 3 years. John.
You've been in jail 447 days, sir. That's just a little over a year.
From approximately December the 9th of 2023, or we'll say when I left home from Dallas. I've been away from my home. I'm a domestic homemaker. Do a bottle walking through a walk all the way to 4510 interchange and have Jefferson County come get me up. It seems to feel pretentious that an accidental fire could cause me to lose not only an eye or wisdom tooth, under the care of your doctors. I've never been to prison on all those cases were self-defense cases. I do understand spoken English, and if English had been the spoken language in the United States of America or said area of what is this place called again? Only Beaumont, Texas, where they had a city jail. No, in Jefferson County, Texas. Across county line.
Anything else?
I would like to grant my guilty plea. On my guilty plea, I would like to be killed.
I think that's a little late. It's in the record. When you were under oath and you made your representations under oath. If you want to recant, then the state may consider perjury charges because I found that you were competent and that you understood the proceedings and you made statements that all of this is true, so help you God. Are you saying that they weren't true?
I was off my medication.
Are you saying they weren't true?
I'm just saying that I was off my medication.
Now, are you saying they weren't true?
I'm not saying that I didn't think they were true to the best of my knowledge at said time. Or that maybe prudent to be agreeable. I'm very sorry that there was a fire. Or that I'm here in Beaumont and off the bus and I didn't make it home. I'm sorry, John. I'm very apologetic and sorry for this whole mess with paperwork that work through. I did live in California, Sacramento, Denver, and Aspen, and Seattle, and near Cleveland, near Cincinnati, near Toledo. And been here one time. The whole climate. So it's, it's in 50 months, and I'm still in 50 months. I also been in fear from my life.
Anything else you would like to add, sir?
Do you have any questions? Because if we could say that, so we get in contact with Harris County, see what Judge O said about it, about my 90 days. Because I'm a 90-day order protective custody psychiatric evaluation at a local or North Texas. Okay. I don't think we walking along the beaches in Sacramento. My disability testing, I was saying, over 23 years, it was $23,000, which you're asking me to get you my life saving on accidental fire. And that's all it would be for all these other things. I'm going to.
Anything else you want to add, sir?
What can I do to please the court?
You're not negotiating with me, sir. I make findings and the court will make rulings under law of what the court has the authority to do. But I can't bargain. I'm not bargaining with you. That's not for me to do, sir. I will make findings and rulings of law. Is there anything else? Do you want to ask Mr. West anything more?
Well, I want to let you know that my affidavit was paraphrased and it should not be used as a sole prosecutor device to convict me. Thank you.
Okay. Anything else? You may be seated, sir. Thank you. The court, is there anything else from the defense or the state? Nothing further? Nothing further? Mr. Weaver, anything further?
Yes, sir. I was impersonated poorly.
You were what?
Impersonated poorly in some of these findings against me. Some of those criminal convictions were people impersonating me poorly, Your Honor.
Okay. Anything else?
I am a psychiatric patient who deserves to be given an opportunity to go to a psychiatric hospital, as well as a doctor's order, doctor of law, and a doctor of law, Your Honor.
Okay. Anything else?
No.
No. All right. And so the court made its findings based upon what was presented at the time of the entry of the plea, that the defendant was mentally competent to enter his guilty plea. He did understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting his guilty plea to find him guilty beyond a reasonable doubt, and I found him guilty beyond a reasonable doubt of the second-degree felony of arson and sentenced him under the agreement to confinement in the institutional division of the Texas Department of Criminal Justice for a term of 10 years. That was suspended. He was placed on regular probation for 10 years. Among other conditions of probation, such as reporting regularly that he failed to do from the outset of probation, he was ordered to pay restitution, $1,675.
Yes. Our paperwork is.
So the burning of a vehicle?
Yes, sir.
Okay, I guess it wasn't totally burned. I guess.
It wasn't much of a vehicle.
And it wasn't much of a vehicle, according to the state. All right. What is the state summarizing and asking here?
Judge, here's the Problem with Mr. Weaver is that he's not going to comply with probation. It's apparent. I mean, he's had opportunities, had probations before, but this time he's decided not to. He's a danger. If he gets out there to himself or others, I think he could end up either hurting himself or hurting somebody else because of his priors with combative nature of police. We'd ask in court, we don't want to place him in the penitentiary for a long time, but we would ask for 3 years in prison. I think that's fair. I don't think he's going to come back and comply. And I think that will also give him an opportunity while he's there. They do have mental facilities that they can place him in, and they would have plenty of time to work with him and make sure they get him straightened out before he gets back on the street.
Did you want to add anything to the record here, Mr. Weaver?
I'm very sorry to this accident happened, Your Honor, and any harm that I've caused. I apologize profusely, and thank you, Your Honor. Thank you.
If nothing further, I'm going to find that there is sufficient evidence supporting this first amended motion to revoke probation, to grant it by a preponderance of the evidence or greater. This motion to revoke probation, first amended motion to revoke probation filed September 3rd, 2025 is granted by a preponderance of the evidence or greater. Court has revoked your probation of 10 years in this case, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years, and restitution will be ordered. I have restitution in the amount of $1,675. That will be ordered, and hopefully you can somehow do something to pay that back. Do your best to fix this. The sentence of 3 years is what this court finds is fair and appropriate under the circumstances of this case. Do you understand what has happened today, sir?
Yes, sir.
And again, you will be given credit for the 447 days that you have already served in connection with this case. Anything else?
Yeah.
If not, we are in recess. Thank you.
And that is how the cookie crumbles. Ladies and gentlemen, that does it for another President's Day special. Wasn't quite the 5-hour Mogan extravaganza we had last year, but hey, it was some good stuff from the Wayback Machine, and we got it out of the way from the backlog, so I'm happy. I hope you're happy too. I know we're all much happier than most of the people we saw in the court cases tonight, with the exception of the first family who actually got their civil protection order, and hopefully they're having a much better few days since that, because that sounds kind of crazy. Having your neighbors put, I have cameras, but they're not on like turret poles with 365 degree crazy view range and stuff. That's kind of out there, right? I mean, who knows? Ladies and gentlemen, we're going to watch some stuff with Sovereign Legal Encounters. That's our good friend Hutch. I have it on a good authority that he has a real interesting premiere happening right now, ladies and gentlemen. And if you want more stuff just like this, make sure you come on by here every single night of the week. That's 8 p.m. Central Time, 9 p.m. Eastern Time. I'll be here with some more court cases of the day, if the courts are active during the day. Yeah, that's what we do around here. We also do it on the weekend. Don't forget to like, comment, and subscribe, because that's what us YouTube personalities have to say all the dadgum time. And I'm a personality, I guess. I do want to say a special thank you out there to Stephen Sky Reading and Sovereign Legal Encounters for their generous donations. That always puts a smile on your face. People like me. People really, really like me. And I love you all so very much. I am your lone wolf Usul. I'm your curator for these here videos, your humble court correspondent, wearing a Star Wars t-shirt and with puppies on the couch. Ladies and gentlemen, I appreciate you all. I hope to see you again soon. But for now, I'm going to try and say a few final sentences, and in and amongst them, I will say thank you, good night, and I am out. Now go watch some Hutch. How about it? Get out of here. Sovereign Legal Encounters awaits. Have a good night, ladies and gentlemen. Oh, wait. I messed it up. Bye.